It's all about the distinction between regarding communications as internal to the UK or external. And this is obviously important because there are tighter restrictions on examining internal communications than there are on external ones. For that reason, the RIPA, the legislation, draws this distinction. In the past, it was quite easy to interpret what was internal and external. So a letter posted overseas or an international telephone call was self-evidently an external communication. But this is much harder in certain areas to do with internet activities. So I've got my 4 examples that I hope you'll help me navigate. First of all, in terms of an email, it's obvious that if one or both of the sender and the recipient is overseas, then that would be an external communication. But can you confirm that if both the sender and the recipient are in the UK, it will always be treated as an internal communication, even if it's routed overseas during its journey? Could we look at that one first, please?
So this, you said an email.
An email from me to you. We're both in this country, even though, as a result of the arrangements, it may have bounced back and forth with servers overseas.
Yeah. So I think, and I invite my colleagues to step in if I get this technically wrong, but I think it is, you're absolutely right, Mr. Lewis, to identify that because of the technology that exists, these issues have become more complicated. An email which originates or is received in the UK, whether both of the parties are in the UK or only one of them is in the UK, is an internal email. It is, however, the case...
I don't think that can be right, not if only one of them is in the UK.
I think it is in terms of access to its content would require a warrant under Section 8.1.
So if both ends of the email are in the UK, it is treated as an internal communication.
Yes, but that's not what the Foreign Secretary said.
But if only one end is in the UK, it will still require a Section 8.1 warrant to access the content. Yeah?
Yes, but that is an external communication.
Let me finish the train of thought, and then we'll if I'm being unclear, I'll correct myself. But my understanding is that because of the technical nature of the internet, it is possible that in either case, it is possible that such a communication could be routed through servers that are outside the UK. It is possible that data so routed could be intercepted as a result of a warrant under Section 8.4, but it would not be possible for that communication to be examined or analysed without a Section 8.1 warrant then being issued, because the persons involved or one of the persons involved is in the UK. Now, if I've misrepresented that, please correct me.
Yes, but the point I want to establish is that different warrants allow different levels of intrusion. And you do have to have warrants of one sort to deal with external communications, that is, from somebody within the UK to somebody outside it. But if that person is communicating with somebody within the UK, that is regarded as an internal communication, requires a different sort of warrant.
My understanding is that a Section 8.4 warrant will allow external communications, those which are between two parties outside the UK.
Or one party outside the UK.
Or one party outside
it's
the UK.
It's external if one party is outside the UK.
Okay. But I think then that requires a 16.3 if the content is to be examined.
Yeah.
Right. So for practical purposes, the point I'm trying to make is that through a combination of the use of Section 8.1 warrants and Section 16.3 warrants, it is the case that however it is originally collected, if an email has a party to it, either the recipient or the sender, who is in the UK, then it will require a further warrant to be issued, either Section 8.1 or Section 16.3, before that email can be examined. Whereas if it is an email passing between persons, both of whom are outside the UK, it could be examined under the authorities granted under the Section 8.4 warrant. That's not an open-ended right to examine that email. The Section 8.4 warrant itself will define the filters that have to be applied for the examination of such an email.
So what you're saying then is that an internal communication, as I understand it, an internal communication applies not only if both the sender and the recipient are within the UK, but even if only one of them is within.
I'm sorry, I've misled you in my use of terms. I was trying to be helpful, but I fear I've been unhelpful. It's an internal communication if both the sender and the recipient are in the UK. If one of the sender or recipient are in the UK, it's an external communication. But for it to be examined, because one of the sender or the recipient are in the UK, it will then require a Section 16.3 warrant to be issued before that communication can be examined.
And I think, just to be clear on that, I think a 16.3 is described as a modification rather than a new warrant.
Yeah, well, that you'll be pleased to know was the easy one.
Good.
Now let's go to